There we go. Hello, everyone. Just gonna give a few minutes for people to join. Gonna give everybody another minute or two or so to join, and then we'll get started. What do you think, Pam? Should we give it one more minute or?
Yeah, one more minute.
Yeah, it's like 120 people logged in so far, it looks like. So. All right, while we wait for a few more folks, I'm sure will join. We'll get started. So I'm Matt Gaines, and joined with me today is Pam Jonah. We're both partners here at Marcus Arrico, Emmer and Brooks, and we're going to take you on an in-depth discussion about all things you need to know about reasonable accommodations and modifications in condominiums and HOAs. We're going to try to do this as in-depth as possible. Pam and I have done this a few times before, so we hopefully have anticipated a lot of questions and will likely get to them at some point during this presentation. So with that being said, we're gonna, obviously, if you have questions, feel free to use the Q&A feature on the Zoom. But we are going to hold off on answering them until the end because we have a lot of material. We want to get through it. We want to try to keep it to an hour or a little bit more. Obviously, we're happy to stay on longer at the end to answer any questions. So we will be, again, ask your questions as we go, but we're going to wait to answer them to the end. And I think you'll be surprised that there's a good chance we'll probably end up addressing your question at one point during this presentation. All right, with that being said, why don't we jump right in? All right, so again, we're talking about reasonable accommodations and modifications in housing, and when and why boards need to approve such requests when they come in from residents. And so the first part of it is, well, why? What is the foundation for this? Where do these accommodations come from, and the reason why boards need to deal with them and likely approve them? And it's based, excuse me, both in federal law and state law. The federal law being Title 7 of the Civil Rights Act of 1968, better known as the Federal Fair Housing Act, or even more better known as simply FHA, the Fair Housing Act. In addition, you have Massachusetts state law, which is Massachusetts General Law, Chapter 151B. I do know, and I probably should have included the sites here. I apologize for any of our friends in New Hampshire and Rhode Island, but there are similar statutes in those states as well. And for the most part, whether it's the New Hampshire, Rhode Island, Massachusetts statute, or the federal law, they all basically say the same thing, which is that in the housing world, you cannot prohibit based on, or you cannot discriminate rather based on a certain set of protected classes. And among those protected classes are based on race, color, religion, national origin, sex, gender identity, sexual orientation, age, marital status, familial status, and disability. Today, we are talking about the last one, disability, in that you cannot discriminate in housing based on someone's disability. One other quick point here, which is a common misconception, is about whether or not the American with Disabilities Act, the ADA, and whether or not that applies. That does not apply to a strictly residential housing property. If you happen to be a mixed-use property with some commercial component, then it might apply. But it is a common misconception. The ADA, American with Disabilities Act, does not apply. The ADA only applies to places of public accommodation, such as an office building where our office happens to be, stores, restaurants, malls, movie theaters, all places like that, which are open to the public. The ADA applies to there, but a condominium or an HOA is not actually open to the public. It's private housing. So again, the ADA does not apply, but the federal and state laws do. Before we delve into law a little further, the reason why we feel this is such an important topic is, frankly, what can happen to you if you do discriminate? I put this at the beginning to sort of scare you, frankly, and to tell you, okay, if you don't pay attention here today, what are the consequences? Well, the party who feels they've been discriminated against due to their disability can file a claim. In Massachusetts, you would file it with the Mass Commission Against Discrimination. And the MCAD could impose injunctive relief, meaning basically forcing you to grant the accommodation or the modification the individual has requested. The MCAD could impose damages upon, or award damages, I should say, upon the person who has discriminated, and the association would have to pay it. That could mean that, if the person ended up moving out because they didn't get their accommodation, they had moving expenses, maybe they have a higher condo fee or a higher mortgage or whatever it might be at their new place, those would be damages that the individual incurred. Out-of-pocket expenses, again, moving expenses, legal fees. There's always going to be a claim for emotional distress. And not only could you have to end up paying the residents' legal fees for that cost, but obviously you're going to have your own fees. If you end up hiring our office or some other law firm to defend you, you would have those legal fees incurred, which can be quite significant to defend a discrimination case. And finally, the Mass Commission Against Discrimination, as does HUD, the Department of Housing and Urban Development, has the power to levy fines and sanctions upon an association if they found that discrimination occurred. And I've seen them in cases anywhere from $10,000 to $25,000. While your directors and officers insurance carrier might not guarantee, but might provide a defense in a discrimination case and cover legal fees to defend it, your D&O will not cover fines and sanctions or other penalties or other damages. So again, as you can see, the consequences for failing to provide an accommodation or modification when you should can be quite significant. Okay, so back to sort of the main focus here is, okay, so you've got a request for for accommodation, and if you fail to do it, it can be discrimination. And what does that mean? Well, again, the discrimination as it pertains to a disability would be a refusal to make a reasonable accommodation, which is basically an exception or a waiver to some type of restriction, rule, or policy, when that accommodation is necessary for the individual, the disabled individual, to have an equal opportunity to use and enjoy the unit or the common areas. So again, the best example, which we'll talk about in more depth later, is that if you have a provision in your documents that prohibits dogs, and someone asks to have one of those emotional support animals, that would be a reasonable accommodation. It's an exception or a waiver of that restriction. And if you refuse to approve it, you may be accused of discrimination and could face a case. Similarly, there's also something called reasonable modifications. That would be a physical change to the premises, typically the common area of the condominium, if the modification is necessary, again, for the person to fully enjoy the premises. The best example, which we'll talk about more later, would be someone who might need a handicap or some type of wheelchair ramp, because there's a couple of steps at the front door and they can't, they have some mobility impairment, so can't use the steps, so they ask for a ramp. That would be a request for a reasonable modification. And again, if the board fails to approve that request, they could be facing a discrimination claim based on disability. All right. So how do you qualify for a request for a reasonable accommodation? There's two very basic criteria that the resident must meet in order to qualify for a reasonable modification or accommodation. Number one, that person must demonstrate that they meet the definition of a disabled person, and I'll describe that to you in a minute. In addition, the person has to establish some type of nexus or relationship between the disability and the accommodation or modification. To put it another way, how will that modification, how will that accommodation allow the disabled individual to enjoy the housing? Again, for things like ramps, it's obvious, right? They can't get in the front door because there's steps. So the nexus or relationship is obviously the ramp helps them get in the front door. So with that in mind, on those two criteria, let's break down the first one a little bit more. What is the definition of a disabled person? And the definition is the same both under the federal and state law here in Massachusetts. And the definition of a disabled or disability is a physical or mental impairment that substantially limits one or more major life activities. Is also a record of having such impairment or being regarded as such impairment. The last two, what those really mean, a record of having such impairment might be that if you happen to have a handicap placard, or maybe you get Social Security disability benefits, that would be a record of having an impairment. And being regarded as having one would be maybe if your disability is obvious and you can see it, it's known that you have that impairment. We're really going to focus on the first bullet here about what it means to be disabled. And it's, again, having a physical or mental impairment that substantially limits one or more activities. So what does that mean? Oops. So example of physical impairments are someone who might be blind, deaf, they're wheelchair bound, or otherwise have some type of mobility impairment that makes it difficult for them to walk. Those are examples of physical impairments. Mental impairments. I put a list here. Obviously, this is not a total exhaustive list, but typical mental impairments that we see for requests are depression, anxiety, panic disorder, stress, OCD, PTSD, any type of learning disability, autism, ADHD, and ADD. Those are all examples of mental impairments that could, necessitate someone needing a reasonable accommodation. Then again, going back to that definition, it was a physical or mental impairment that substantially limits one or more major life activities. What are common life activities? There's a list here. Again, obviously not a total list, but some examples that we usually see. And it's everything from, obviously, seeing, hearing, eating, walking, standing, but also things like caring for oneself, sleeping. That's certainly a major life activity. Working, concentrating. I didn't put it on here, I don't think, but socializing. That's one we have a lot. So to kind of put it all back together, you have a physical or mental impairment that substantially limits one or more major life activities. So if you have a physical impairment in that you are blind or deaf or have a difficult time walking, obviously the major life activity impacted by it would be seeing, hearing, walking, and therefore you meet the definition of a disabled person. Similarly, for mental impairments, if you have stress, depression, PTSD, anxiety, it is likely going to impact your ability to maybe sleep or work or socialize or care for yourself. So again, if you have that PTSD or that depression, it impacts your ability to work or socialize, you have a mental impairment that substantially limits one or more major life activities, in which case you may be entitled to a reasonable accommodation. I'm going to turn it over to Pam now, who's going to kind of take you through what next if you get one of these requests.
So Matt's covered the law in terms of why you have to be aware of this. Now we're going to delve into what do you do when you get a request for accommodation or modification. One of the most important things to know or recognize is that the request can be made verbally or in writing. I know oftentimes associations set up policies that, if you're going to make a complaint about something, it has to be in writing. But this is one of those areas where you can't set up a policy and say, if you want an accommodation or a modification, that you have to put it in writing. You have to accept that the person can come to you and verbally request it. They don't have to use the magic words, reasonable accommodation or reasonable modification. They just have to give you some sort of indication that the requester is asking for a waiver of either a rule, a policy, or that they're asking the association for permission to either make a modification to a certain area or for the association to make the modification to the certain area. Because we're typically talking about the common area, and that's typically going to be on the association to make the modification because the board controls the common area. Another key thing to consider is that the request can come from pretty much anyone. So I know, again, oftentimes we advise that boards and property managers really only have to deal with the owners. So if a tenant is acting up in a violation manner, we typically will have the letter of violation go to the owner, and then the owner is supposed to go and take care of, the tenant and let them know to knock it off. But in these instances, the request can come from the owner. It can come from the tenant. It can come from a family member of the owner or tenant. It can come from a prospective buyer of a unit. It can come from a prospective tenant. You have to deal with these requests before the person even owns the unit. It can also come from a guest of an owner or tenant. So if there's if there's a person that frequently visits the owner or tenant is going to come to the condominium and they're disabled and maybe they have an assistance animal, they can ask the board to give them permission to bring the assistance animal as a guest to the condominium. So you have to get over the fact that you only deal with the owner and realize that the request can come from numerous people. Do not deny, I know in a lot of times boards will say, well, this is a no pet, we have no pets. We do not allow dogs. So therefore, nope, go away. We're not going to even consider your request. Once you've denied a request, if that person in fact would qualify for the accommodation, you have now committed discrimination. So it doesn't matter that maybe you then find out, oh no, we'll consider it and now we'll allow you. That person actually has a claim at that point because you've already denied them. So they could even get the dog and still file a claim with the commission saying that, you know, somehow you caused them emotional distress because in the initial stages you simply denied. Another key thing to recognize is that the courts have been very adamant that you have to engage in what they call an interactive process. Both the regulations and the courts have stated this numerous times. Interactive process, what does that mean? It means that when you have an inkling or somebody specifically does ask you for an accommodation or a modification, then you have to engage immediately, essentially, in finding out what it exactly is it that they're asking for, and let them know. In fact, the law expects that the board and property managers will be well versed in this area of the law. They don't expect that you'll even have to go to your attorney and ask them what to do. You know, they basically expect you to know that, you know, these things exist and you have to handle them properly. So another thing, must provide a prompt response. Undue delay in responding may be deemed a failure to provide the requested accommodation or modification. So somebody asks you for, you know, to allow them to have the assistance animal, the dog, in a no pet community. And, you know, you're sitting there and you're thinking about it and you're contacting your lawyer to find out, you know, what's the process? What do you have to do? Silence can be deemed a denial. So it's not something that you can sit on for very long once the request has been made. In fact, oftentimes I'll receive something from a property manager saying, you know, there's a resident and they want to have this dog, but this is a no pet community. And the board, you know, is going to meet in a month and they're going to discuss it and they need to know what it is they need to know. And I always say they can't wait a month. You can't wait a month to discuss it. The law, you know, again, somebody's going to run up to the MCAD and file a complaint, whether they qualify or not, because you simply haven't reacted quick enough for them. Once you find out that they do qualify, and we'll talk about how they qualify later. But once you've determined that they do qualify for either the exception to the rule or policy or for the modification, you can approve and you can put conditions. Basically, the conditions usually come about with the assistance animal. So you're allowing the dog, and now all of a sudden you have to come up with assistance animal rules, because you wouldn't have a set, presumably, of pet rules because you don't allow pets. It might be an instance where you allow certain pets and they want a different kind of pet. So you might have like a 20-pound restriction on all dogs, and they want to move in with a 100-pound dog, and you've gone through the whole process and their medical provider has basically said, yep, they need this 100-pound dog. So now you have to make an exception to that rule. Well, now you have pet rules, but you don't have assistance animal rules, and they're different. And I'll get into that further. So, you know, once you're in this area, you're probably going to need to have a set of assistance rules so that you're ready to grant accommodations subject to those rules. I never recommend denying without at least contacting your lawyer once, because you just never know. There could be a reason that you're not aware of, that perhaps they do qualify or that they should be granted the modification. And once you've denied, you've set yourself up for a claim at the commission. So now this is the interactive process, and I probably, as I usually do, have kind of already gone over it. But basically, again, you have to have a back and forth. You can't just take the request and kind of disappear for a certain amount of time. You also can't just say, well, they didn't articulate what they're looking for well enough, so we're just going to say no, because we either don't know what they're looking for, or we don't think what they're looking for is possible. So therefore, we're just going to straight up say no. Again, the law expects that the board and the property manager is well versed in this area of the law, and therefore they put the onus on you to go back when you don't understand what they're looking for. If you think that you can't do the modification that they're looking for, you still have to engage in this interactive process where you don't just deny, you go back and you say why you think you can't accommodate them. And perhaps there's another accommodation that will meet their needs. So that's the back and forth. That's the interactive process. Oftentimes, a resident or requester will ask for an assistance animal, and they'll give you a certificate that just shows a picture of the dog, and it says on the certificate, this is a service animal. And under the law, that's not enough. So, but can you just say, well, too bad, you didn't give us what's required, so we're going to deny it? No, you have to go back and you have to tell that particular requester what exactly is it that's required under the law in order for them to meet the criteria of the accommodation, or at least give the board the material and information that the board needs in order to consider the accommodation. What information, if any, is necessary to establish the nexus between the request and the disability, and if applicable, discuss alternatives. Essentially, I believe I delve into this in more depth later, but when we're talking about assistance animals, unless the disability is open and obvious, such as a blind person needing a CNI dog, I mean, basically the process stops there because, you've already established that they need it. There's nothing to discuss at that point. You just have to allow it. But the procedure is, so establishing a disability. A disability is established if it's open and obvious. And usually these are the physical ailments, right? You usually won't be able to look at a person and know for certain that they have PTSD or that they suffer from anxiety or a certain amount of stress. But you can look at a person and usually can tell if they're blind, or you can speak with somebody and tell if they have a hearing impairment. You can certainly tell if somebody's in a wheelchair. You can see if a person is using a walker. So those are all open and obvious disabilities. Again, another possibility would be the fact that they receive disability benefits. If somebody's receiving disability benefits and they show you some evidence of that, or you have some reason to know it, then I guess you have some reason to know that they're disabled. Substantiation from a credible source. I mean, I think that more or less is like, open and obvious, or, the spouse says, oh, my husband is hearing impaired, and they should know, so they're a credible source. If the disability is not open and obvious, then that's when the board is able under the law to request medical documentation. What does that mean? You can't request a copy of their entire medical record. That's a HIPAA violation. You basically have to let them know the two criteria that they need to confirm through the medical documentation. We typically do that through a letter. We also use forms that we've designed to help out to establish whether somebody, so that the medical professional can provide the information that the board needs in order to consider whether somebody's disabled and whether they actually need the assistance animal, or whether they need a modification if the physical impairment is not open and obvious. But we cannot require the doctor to fill out the form. So if you give the form and the doctor, or I shouldn't even say doctor, it's medical professional, because I'll get to that. It doesn't necessarily have to be a doctor. But if they give you a letter and the two criteria are explained in the letter somehow, and I find that a lot of medical professionals now do know exactly the buzzwords, the keywords under the law, that this person suffers from a disability that affects their daily life activities, and that they'll benefit from the use of, usually it's an assistance animal. They'll benefit from the use of being able to keep Muffy. So therefore, I'm prescribing Muffy, please let them have it. That's enough. What's in the letter is enough. You can't, and, I find oftentimes too that, boards will say, well, you know, they have a 150-pound dog and we have like a 25-pound limitation on dogs. Why can't we go back and say, you know, can't you have a 25-pound dog? If the dog already exists and they already have the dog, most likely you're going to get stuck with the dog that exists. A medical professional is not going to tell somebody who's suffering from anxiety, PTSD, or whatever the disability is that requires them to need the assistance animal. They're not going to go back and say to that person, you know what, the association says they only allow 25 pounds, so therefore you should get rid of the dog you have and get a 25-pound dog. If they come to the association and they're there and they approach you and say, you know, I think I need an assistance animal, or I'd like, you know, my doctor or medical professional thinks I need an assistance animal, and they don't already have a dog, then you can start saying, well, is it possible that it could be a 25-pound dog or a 50-pound dog or whatever it is that the association thinks would, you know, be more beneficial to the other residents, because, you know, they're expecting either a no pet community or a limitation on size. That's when you can get into that. Does not need to be a doctor, does not need to be a psychiatrist. It can be a doctor, it can be a psychiatrist, but it can also be a social worker, a therapist, a sociologist. I don't even know if I'm saying that right. It can be a nurse. It can be an assistant to the doctor. So you can't get hung up on the fact that it's not a doctor that's providing the medical documentation. You can't share, obviously, the medical information with the rest of the community. I know I've had this question come across quite a bit. Well, everybody else in the community is going to be asking the board, why is this dog on the property? And I'm sorry, I just keep talking about dogs because we're talking about modifications too, but I think, you know, people get most upset about the assistance animals, so I tend to kind of go there. But, you know, they want to put out a bulletin essentially, or a letter to the community explaining why this particular individual was granted an accommodation and needs the dog. We never suggest that. That's like basically calling attention to the entire community that a certain individual or resident has a disability, and that would be an invasion of privacy. So you can't do that. What you can say, and I think this comes up later on, is basically, you know, the board was faced with a request for an accommodation, and under the law, they had to grant it. Period, end of story. And again, you never should actually, if somebody says, you know, I need an assistance animal, you shouldn't say to them, well, what's your disability? Under the law, you're not supposed to ask somebody specifically what's the disability. You're just supposed to tell them that they need to get the medical documentation. And oftentimes the disability will be revealed in that medical documentation. But, you know, you can't say the words, what is it? Next slide. Circumstances under which, circumstances under which you can deny a request. Almost never, no. Really, seriously, almost never. You know, there have been times, so if they don't produce the documentation, say, and they never produce it, you've told them what you needed, you've given them 30 days and they haven't produced it. I like to extend and give them another chance. Only because sometimes we recognize that you can't always, like, if they don't already have the documentation in their possession, they might have to make an appointment with their physician, and the physician may not have availability for them within that first 30 days. So I generally recommend giving an extension of time, especially if they've come back and told you, like, you know, I'm waiting, I have an appointment on the 25th or whatever. I would not suggest denying. I would definitely give an extension. But, you know, okay, so they give you the documentation and it doesn't meet the criteria under the law. It fails to state that they're a disabled person. Now you got to be a little bit careful. You got to read between the lines. So if the medical professional has written something in the you know, the letter format of a letter, and they may say, this person suffers from anxiety, and therefore I recommend that you allow them to have Muffy because that's going to help them. I don't typically push back and make a medical professional say the word disability. We all know that anxiety is an accepted on the list of common disabilities. So there's really no point in going back at that point. Sometimes you have to read between the lines. The words are there. You have enough. I would recommend at that point that you have to grant the accommodation. If the accommodation would cause a direct threat. So, somebody, this is a horrible example, but somebody's a drug addict and they say, oh, I need to be able to do my drugs on the property because I'm addicted, right? Maybe they come up with some disability that's, I suffer from this disability. This is why I'm a drug addict. I mean, you don't have to allow that, right? That's against the law. But typically another time that might come up is, well, the dog seems aggressive, the dog that they're trying to get as an assistance animal. He appears to be aggressive. He's already lunged at somebody. Okay, yes, they may seem threatening, or so-and-so's deathly afraid of dogs, the other residents that live here, and they specifically identify a particular neighbor. They're deathly afraid of dogs. Therefore, we can't allow this accommodation. Unfortunately, that's not the way it works. So both the MCAD and even I believe the regulations have stated specifically that they basically expect the board to do the best they can to work with the individual who has the need for this particular dog to ensure that they can reside on property and maintain the dog. So maybe if a particular dog has actually continually lunged at people and made a, some sort of indication that they might bite, you might be able to require them to wear a muzzle when they're in the common area. There's workarounds that you can suggest that maybe lets the person keep the dog. So I don't find that there's often a direct threat example where you just simply deny. If the request is not reasonable.
The only thing I was just going to add to what Pam just said
Yeah,
about
sure.
direct threat, because we get the question a lot, is that, someone wants to bring in a pit bull or a German Shepherd, can we deny? And the guidelines from HUD are very clear that you can't deny based upon speculation or generalization about, a certain type of breed that may have, dangerous tendencies. You can only deny if you have specific knowledge about that specific dog having some type of aggressive past. So, I kind of joke, what are you supposed to interview the dog and see if it, bites you in the face or something? I don't really know how you determine that, but you can't deny just based upon speculation or generalizations about a breed.
And to your point, Matt, too, especially with the breeds. So we know that a lot of insurers, the master insurer policies, they'll say, we're not going to provide insurance if you allow pit bulls, German Shepherds, the various breeds that they list. There's actually a HUD or in Department of Justice memorandum, I think it was in 2013, that they distributed it, that said, we don't care if the insurance company has a list of non-acceptable breeds. We expect you to go out and find another insurance company that will insure the condominium so that this person can maintain a pit bull or German Shepherd or whatever animal it is that is on that unacceptable list in terms of the insurer. They even suggest that you report that particular insurer to someone. I don't know exactly who you'd be reporting them to, but they go that far.
I think a lot of insurance companies are getting away from that as well, because they know that they're exposing themselves somewhat to discrimination, and they might lose, clients if they have some type of language in their policies that says we don't want to insure if there's, these certain breeds there. And I know I saw that was one of the questions in the chat. And by the way, for those that joined late and missed my announcement at the beginning, we will get to all the questions that I see popping up in the Q&A just at the end. So continue on, Pam, sorry.
Sure, no. Another circumstance under which you can deny a request, if the request is not reasonable. So this would typically come up in the case of a request for a modification to the common area. So it's basically the request is not reasonable because it would impose an undue hardship upon the housing providers. And one of the criteria would be because of the cost. Okay. So I oftentimes get, the pushback from a board saying, well, this person says that they need a handicap ramp, and we've done the research. It's going to cost the association $35,000 to install the handicap ramp so that this person can get access to the front of their unit and use, the front door. And this, that's way too much. That's got to be reasonable and unreasonable enough for us to deny it. I've sat in MCAD seminars similar to this, and they basically know that the association has the ability to raise common fees. They also seem to think that the association is this big corporate entity with this unlimited budget. And unfortunately, I can tell you right now that most likely $35,000 is not going to get you off the hook. You're going to have to use the common fees, and if necessary, raise the common fees. If you don't already have that type of money in the reserves, you probably won't have it in your budget, because these requests, aren't typically anticipated all the time. Next slide.
I just want to add one more on the,
sure.
on the second bullet there about the nature, if it's physically impossible for the modification to be
Oh,
installed.
sure.
To give you an example, I actually had about probably 5 or 10 years ago now, where an owner, there was like a parking lot, and there was a few steps up to this walkway, and then this long walkway to the front door. And this owner with the mobility impairment couldn't really navigate those steps in the parking lot. And so she asked for some type of ramp. But again, the steps were pretty much right in the parking lot. There were parking spots on either side. And, if you put in a ramp, it obviously has to be to code, which means, it has to have so much slope for every 1 foot of ramp. And so in order for the ramp to really fit, it would have to have, zigzagged at least once or twice to make the slope to code. And the only way to do that, obviously, is that the ramp would have effectively gone into other people's parking spaces and obviously impacted snow removal and everything. So we said, listen, it's physically impossible to put this ramp here. If you can find us an engineer that can somehow structure this in such a way, great, but we don't think it can be done. We denied the request. She filed the claim with the Mass Commission Against Discrimination. The investigator suggested, why don't we all go out to the site and take a look so I can better understand what the issue is. I said, I'd love for that, because I knew as soon as she got there, she would see the problem. Sure enough, we were there for about 5 minutes, and the investigator from the MCAD said, yeah, I don't really see how a ramp could possibly be put in this area. So, while, the circumstances under which you can deny are not many, that there are some. And if it's just, physically impossible for the modification to be installed, that would be a situation under which you can deny.
Yeah, and certainly if it's not going to meet code. So that's, it's one of the things that I always do first recommend is hire a professional who knows about what's necessary to install the ramp, that knows the code. They're going to visit the town hall, find out what the requirements are. And if it's physically impossible to do the modification, as Matt said, then that would be a case in which you deny. I just don't find that it comes up all that often.
It doesn't, but yeah.
Right.
So.
Okay, next slide.
All right, next. So we've talked about, obviously the law, we've talked about, what kind of the process for handling these requests, and then what are some typical requests? And here's some examples, again, for modifications, wheelchair ramps. I also handrails, like an extra grab bar or handrail along a walkway, a stairway chairlift, those automatic door openers that you push the button and the door opens. Those are typical examples of modifications. And I'm going to delve into each of these a little bit more detail. And then again, on the accommodations, someone might want a designated handicap parking space, perhaps the use of a generator, and of course, the assistance animals. We're saving that for last because we know that's the most, we've already talked about it a lot. But, just quickly on the stairway lift, on that topic, by the way, that's another one going back to the point that Pam and I just made about, maybe it's physically impossible to install it. And, that's a situation where there's no elevator in the building. Somebody lives on the second floor, and maybe when they moved in, they were perfectly fine. But they had some tragic event, and all of a sudden they can't use the stairs. So they've asked for one of those sort of ride-on lifts to be installed. Well, when you install that lift, it obviously takes up a portion of the stairway. Under various building codes, stairs must be a certain width. I can't remember off the top of my head what the amount is, but it's like 4 feet or something like that, a minimum, width of the stairway. So if the minimum width by code is 4 feet, and the stairs right now are maybe only slightly more than that. Well, once you put the lift on, it's going to be less than 4 feet. It's not to code. And one of the things that I've done in that situation, so that the board or the management company doesn't have to be the bad guy, is I'll actually get the building inspector to come out, and sometimes he'll issue a letter or at least an email that says, yes, your stairs are only this wide to begin with. If you put the lift on, they'll be, obviously not quite as wide, and therefore they won't be to code. So therefore you cannot put this lift in. And that's an example of a physical impossibility. The automatic door openers come up when, maybe somebody, again, due to some physical issue, has difficulty. They're not strong enough to pull the door. And so again, they need one of those automatic door openers. So just to kind of, go through these a little bit more about, and again, talking just about reasonable modifications, just as a reminder, that being a physical change to the premises. If the modification is to the unit, maybe they need, some type of grab bar to get in and out of the shower, or maybe, if they have a wheelchair, if there's like thresholds going from room to room, they want those removed. Obviously, that's, just like any change to the unit, that's going to be at the unit owner's expense. And for the most part, the board doesn't usually even need to get too involved with that. Obviously, if it's something structural that they need to do in the unit, you just want to make sure it's not going to impact the structural integrity of the building. But for the most part, there's really no reason why the board should be too involved in that. The owner can do it, and it's at the owner's expense. That's in the unit. Again, the more common examples, though, is if the modification is to the common area, talking again about the automatic door openers, the stairway lift, adding an extra railing along a walkway because someone is a little unstable, and of course a wheelchair ramp. Again, all those situations, as long as they meet all the criteria that Pam talked about, the board would have to approve the request. And then of course the big question is, well, okay, this is a modification to the common area, but it's really only to benefit one person. Who has to pay for it? Well, Massachusetts, as far as I know, might be the only state in the country. I know certainly it's the only state in this region that under the law, it actually says that if the modification is to the common area and there's more than 10 units in the association, then it will most likely be at the association's expense. There are a couple of exceptions that right here. One of them is that if the ramp is for a front entrance of more than 5 steps, or to put in an actual wheelchair lift, not a stair lift, but a wheelchair lift, the association doesn't have to pay for that. So again, if you get a request for an accommodation for a ramp, go out and count your steps. If there are 6 steps or more at your front door, then actually the association doesn't have to pay for it. But if it's 5 steps or less, then the association does have to pay for it. And then the other reason under which the association wouldn't is that what Pam talked about a little bit on the last slide, is that if the cost would pose some type of undue hardship or burden upon the association. And again, as Pam said, it's the MCAD will often look at that on a per unit basis, and that maybe it costs $20,000 to put the ramp in, and if there's only 20 units in the complex, well, that's $1,000 a unit. I don't know if there's no magic number at which it becomes unreasonable, but maybe that is. But if there's 200 units in the condominium, well, that's only $200 a unit. And I can almost guarantee you that the MCAD would not say that that cost is unreasonable. So again, just remember that this is, at the association's expense. Next, our parking accommodation. So this is one that we've seen, actually, I find more and more recently, where, you have a big parking lot and, maybe somebody has a space, way out in the back, space number, 99 out of 100, and it's a long distance from the door, and they have some mobility impairment, and they want a space closer to the door because they can't walk that distance. Does the board have to approve that request? So I always break this down, and the answer, I should say, really depends upon your situation. And there's sort of 3 typical situations for how parking is set up at a condominium. So example number 1, there's 100 units in the condominium, there's 100 spaces. The spaces are deeded as exclusive use easements, meaning that, each person has in their deed that, okay, I own unit 5 and I have the exclusive right to use parking space number 5. In that situation, there's absolutely nothing the board can do to accommodate someone's request who has space number 100 way in the back of the lot, who wants a space up close, because the board has no power to force somebody who has a deeded exclusive use easement to space number 1 right by the front door to give up that right. That is an easement. You have a legal right to that space. The board does not have the power to take that away. The only thing that maybe the board could do is, somehow if there happens to be a little extra space somewhere, the board might actually have to create a new space, rip up the grass and put down, a new space. The other thing the board can do, is, and I've seen this work a couple of times, is put owners in touch with each other. That, you could say, hey, listen, if you have space number 100 and you want space number 1 by the front door, well, here's the contact info for the person who has space number 1. Feel free to reach out to them and see if they're willing to do some type of swap. But unfortunately, we can't force it because they have deeded rights. Next example, again, 100 units in the condo, 100 spaces in the parking lot. The spaces are not deeded or any other way assigned. It's just a first come, first serve situation. When you get home, you park wherever you want to park. Or maybe the spaces, instead of being deeded, they actually are assigned, but they're assigned by the board. So there's no easement. They're not in your deed. It's just the board to have some order that said, okay, we're going to do assignments. In this situation, the board does have the requirement to act here and grant the accommodation. So again, if this parking is just kind of open, the board would actually have to then reserve a space. And so if someone wanted space number 1 right by the front door, the board would then have to mark that space as reserved so that no one else would park there and that the disabled person could use that space. Finally, the example that I see, you have 100 units, there's 105 spaces, of which, 5 of them are guest spaces, of which all of them happen to be close to the entrance. The disabled resident, again, a space number 100 out in the back, and maybe the spaces are deeded here, maybe they're not, it doesn't really matter. But because there are these open spaces, these guest spaces, the board would have to grant to that disabled resident the right to use a space by the front door. However, that resident doesn't get the windfall of all of a sudden having 2 spaces. So what we do in that situation is a swap, where we say, okay, Mr. Smith, you have the rights to use space number 97. There's a guest space right here. We're going to do a swap. So now space 97 all of a sudden becomes a guest space, and Mr. Smith gets the right to use one of the guest spaces out front, which now would be marked reserved so that nobody else uses the space.
Real quick, I just want to add a couple of things to what you said about the parking, because I think I may have skipped over the fact that if somebody has a handicap placard, that's an open and obvious disability. So this would apply in Matt's whole parking accommodation section. If they already have the handicap placard, you're not going to ask them for medical documentation as to why they need a closer spot. One other thing too, this would also apply to the already existing handicap parking spaces. So if you're an association that has 2 handicap parking spaces, and clearly those are typically under the control of the board because they're not deeded for other owners for exclusive use, and that's your only option when somebody has a disability, is to swap with them and give them the exclusive use, or, a sign that says it's for that particular person. You're going to have to give up that handicap parking space. The MCAD has already, we've had a case on that, so
yep,
will apply.
All right, I'm going to turn it back over to Pam now to talk about what I suspect most of you came here to listen on, and that is request for assistance animals. So go for it, Pam.
And I apologize if I'm repetitive because I usually jump ahead. It's just in my nature. But again, ADA does not apply in housing. So I've oftentimes find that, the board or somebody will do a lot of research and they'll say, oh, the ADA says that if it's a service animal, it has to be trained. And then if it's an emotional support animal, it's different. Basically, it doesn't matter in the housing context, right? Because it's the federal fair housing law and it's the regulations that control and the case law about the federal fair housing law and Mass General Law 151B. So essentially, it doesn't matter if somebody says it's a service animal and it's really just an emotional support animal. You can't get hung up on the terminology. They're basically interchangeable. So emotional support animals, service animals, if they meet the criteria, the medical documentation, the need and all that, it doesn't matter what they're calling it, you have to allow it. We've already talked about the restricting breeds or limits on weight. Again, if the dog already exists, you're probably stuck with that particular dog. If it doesn't, then you can discuss with the requester whether or not you can, limit it to a certain breed or a certain weight. It can be any type of animal. Dog, cat, bird, fish, ferret, snake, pig, iguana. I used to go as far as saying, porcupine. We saw, I can't think of the name of it, of course, because we used to see at the airlines all the funny pictures of typical animals that people were bringing on the plane, pigs, and whatnot. The regulations have come out, they updated them in 2020, and they did somewhat distinguish between typical household animals and exotic animals. So if someone comes to you and they ask for, a dog, cat, bird, fish, that's not considered an exotic animal. And if they meet the criteria, you're going to have to allow it. But if they come to you and they want to, have a pig in the unit, that's not a typical household animal. So in that particular instance, you can say to the medical provider, is there a reason why this person needs a pig as opposed to a dog or a cat? And if they say, you know what, they have the attachment to the pig's what's providing the emotional support for them. Yep, we definitely recommend the pig, then you're going to get stuck with the pig. Can you impose reasonable rules? Yes, absolutely. So you've allowed and granted the accommodation. I always go back to the dogs because those are the typical ones. You can use, must be on a leash, no excessive barking. The resident has to clean up after the dog. But you shouldn't just give, if you do allow certain pets and you already have an existing set of pet rules, you shouldn't just give them those pet rules, because there can be certain rules that would apply to pets that won't apply to assistance animals, such as fees. So a lot of associations, when somebody maintains a dog in their unit, maybe they charge them $250 pet fee a year to accommodate for the potential of damage to the common areas. You cannot impose the fee on an assistance animal or a resident with an assistance animal. If they damage the common area and you can prove that it was their assistance animal that damaged it, then you can charge back that cost of repair to the common area to that particular resident, but you can't do an upfront fee. You cannot require the resident to obtain additional insurance for instances where, perhaps the dog bites somebody. The association's insurance is supposed to have coverage for those instances. And again, a request for an accommodation or modification is typically not supposed to cost the resident any money. So that would be, a requirement that you cannot impose. That's why I always recommend a separate set of assistance rules. You also cannot tell the resident exactly where they need to bring the dog to potty the dog, or you can't tell them that they need to get off property before they can allow the dog to, relieve itself. First of all, it's just completely unreasonable. We all know that, well, we may not all know, but dog owners know that, when a dog has to go, they have to go. Sometimes you're coming out the door, they run over to an area and that's it. They're relieving themselves. So it's really not reasonable to impose a rule that, you have to get off property to potty the dog. You're going to have to bring them to a park or something. Anywhere that the resident is allowed to go in the common area, because this is their assistance animal, whether it be emotional support or service, they need to be allowed to bring that animal with them. So that's going to include the common area lawns. If people are allowed to walk on the common area lawn, the walkways. You can say you can't use people's exclusive use areas, because those belong to other owners. You can make a suggestion perhaps of an area, but you really need to make sure that that person's in agreement with the suggestion, because I had that case go before the MCAD where the board just said you have to take them to this specific area, and the resident was like, well, that's not reasonable because the area is like way out back, way far away from where the resident would be bringing the dog out. And the MCAD agreed. And luckily, we were able to settle that mediation with no money damages. But I can tell you, oftentimes, once a complainant has filed a complaint at the MCAD, they're looking for money damages as well as relief. We already went over that you don't want to announce to the residents, hey, oh, by the way, so-and-so's got anxiety, so you're going to see a dog every day on the, no pet property. What you have to say is pursuant to the federal and state laws, the board was faced with a request for accommodation and had to grant it. Online certifications and letters. This is a big one. So oftentimes, this is an area ripe for fraud. There are definitely disabled people that meet the criteria. And then there are people that just want to have a dog and they're looking for a workaround against the no pet policy. So we all probably know by now that you can go on the internet fairly easily. You can get an online medical professional to, give you a form, you fill it out. They say, oh, yeah, you definitely have anxiety. You would benefit from having a dog. They write this form letter. It's all pretty. It meets the criteria under the law. And they happen to be in Ohio. Okay, so the board gives us the letter and says, this can't be right. We have to grant the accommodation. This person's in Ohio. They couldn't, they probably don't even know that this is the first time they've ever met the requester, the person that's claiming the need for the dog. And unfortunately, we have not gotten enough direction from HUD or the Department of Justice to deny letters, out-of-state letters, because one, they recognize telehealth, especially post-pandemic, right? It's even become more popular to do, health appointments via Zoom when possible. So they recognize that. They don't care that the letter came from Ohio. The certificates that I talked about before, where it's just a picture of the dog and it says this dog's a service dog, they've said that those are not acceptable as meeting the criteria. They need to provide more. But the letter itself from Ohio, most likely you're going to have to allow, because again, they're recognizing telehealth. And I've even had, people move from Florida, so the letter came from Florida, and of course they move into Mass, so then it explains it. But you can't really even delve into, oh, why is your doctor in Ohio? The MCAD doesn't care. Matt, I don't know. Do you think?
No, I don't think they do. I mean, it is, as Pam said, it's an area that's kind of ripe for fraud, and it's tough to know that, when you get these letters that, and again, Pam and I kind of know who they are now, right? I mean, there's a couple of therapists that I've gotten multiple letters from over the years, and I'm like, it can't just be a coincidence that, the random resident at this condo in Revere and this resident at this condo in Lexington both ended up at the same therapist. We know that likely it was through some website, but the HUD has said in their recent publication that a letter, from that may have been obtained online is not, you can't just say, well, this isn't valid. And, is there an ability to push back a little bit, maybe to kind of ask, well, what criteria did you use to evaluate? When I first saw one of these letters, God, it was probably 10 or 12 years ago now. And again, it was from some therapist in like Colorado or Oregon. And I'm like, this is very bizarre. And this is before really the big boom of this whole online, certification of these emotional support animals. So I spoke to one of the other partners here at the time, and I said, what do you think of this? And they said, I don't know. And so I did some Googling, found the website, and sure enough, there's this website where you basically go online, you answer, I can't remember how many multiple choice questions it was, but they were multiple choice questions because we did it. We tried to figure out what would happen here. And the questions, I am exaggerating slightly, but not that much, were along the lines of, when you get home from work, are you, very happy, somewhat sad, very sad? Does your dog make you very happy, somewhat happy, whatever? And those are the questions. And I filled them out, and I didn't give the most extreme example on every one. I kind of, gave it what I thought someone might answer. Sure enough, 24, 48 hours later, we get an email saying, you've been diagnosed with, I can't remember what I was diagnosed with, and we're prescribing you to have this emotional support animal. I'm like, oh my God, it was that easy. It cost $29.99 or $49.99 or whatever it was. In my opinion, an evaluation based purely on multiple choice questions probably isn't really sufficient, but I don't know. I'm not, I'm not a therapist, a psychologist. I'm not a judge either. But I have talked to, I did talk to one of these folks a couple of years ago because I kept getting letters from her, and I finally just called her up, not about a specific resident, but just said, listen, can you help me understand this, what the process is? And she said, she goes, listen, everyone uses a different process. I get why people question this. And she was very, upfront about it. And she did say, she goes, for me, I always have at least one phone call with the person. I said, they do answer some preliminary questions online, but I always have a phone call with them. So again, I don't know how long the phone call is and how in depth it is, but so it's tough to say, on a blanket answer that Pam and I can give you that, okay, just because it was obtained online means it's not valid, because maybe it was obtained purely on multiple choice questions, or maybe there was some questions, but maybe there was a subsequent phone call or some other evaluation. And to my knowledge, even though this has been around now, this kind of online therapy has been around for a number of years, I know there's not a single court case in Massachusetts, because I'm sure I would know about it. And to my knowledge, there's not a single court case anywhere in the country that, a judge has said that these online letters are invalid. So, if anyone on this presentation wants to be the test case, feel free. Pam and I would love to take that case on, but not a lot of people are willing to do that because it is so expensive.
And also with no guarantee, because again,
Right.
we don't know.
Right.
The MCAD is pretty.
Yeah.
They're there to help the disabled. Competing disabilities, so this comes up a lot.
We're, as I say, we're at an hour, and I see that there's 57 questions in the chat. So we'll try to get to these next two slides quick, and then get to some of the questions.
Yeah, I was gonna bomb through.
So I see we're losing a few participants, but we're almost done. Trust me.
Sorry, we're long-winded.
Go ahead.
Competing disabilities. So, somebody needs an assistance animal, they meet the criteria, but then their next door neighbor tells you they're highly allergic to dogs and they moved there because it was a no pet community. Well, that person who's allergic has to prove that, they're allergic to the point of a disability. They would have to provide documentation for that. And, again, the MCAD and the regulations expect you to try to make it work. Is there any way where the dog and the other resident can use one entrance, and then the person with the allergy can use another? You have to try to accommodate both and work it out. If you can't, there is a case in another state that said first in time wins, but there's no case in Mass, so we don't know if that would be what Mass would decide. I don't think the MCAD would say it would be that simple, but that's just my guess. And if all else fails and you don't know what to do, you can hire an attorney to file a superior court case, ask the judge for a declaratory judgment saying, Your Honor, we don't know what to do. This person needs the dog and this person's highly allergic. They're both disabled. What do we do?
Excellent. And then just some final, takeaways here about some, pitfalls to avoid. Again, we've said this many times, but do not deny. You can't really be accused of discrimination until you've said the word no or deny. Now, eventually you'll have to make a final decision. You can't just keep kicking the can down the road, but just don't deny. Make sure you have a good reason to deny. Engage in the interactive process. Pam talked a lot about that. That's very important to do. The MCAD really likes to see that you did that and really tried to work with the person before you denied. Do not delay. Pam mentioned that. Obviously, unreasonable delays are a form of discrimination. I usually tell clients that, try to respond, within 10 to 14 days. Again, sometimes boards will say, oh, well, we're not meeting again for another month. It's 2023. You can meet via Zoom, conference call, email, whatever it is. These things like this can't wait. Again, only ask for the documentation that you're allowed to under the law. Pam talked about that. If you want, maybe put some policies and procedures in place so that, every request is kind of handled in the same manner, so that, one request comes in the next year, another one, and that one's handled differently. It's best to do it all the same. And of course, always, when in doubt, consult with an attorney, preferably one from Marcus Cervico, Emmer, and Brooks. All right, I'm going to go to the questions now. There's a lot. My guess is we answered some of these, but so I'll kind of read them out loud. Can you specifically address assigning parking spaces to condo units? I think we've done that, so I'm going to move along. If you feel I didn't address the question, feel free to put it back in at the end or email Pam and I separately. What did you do? All right, done. Partial answer regarding, do federal and state laws apply to assigning specific spaces to disabled owners? Again, this is a parking question. And yes, as we talked about, the laws do apply, and the board may have to grant that accommodation, depending again how your parking's set up. Long ago, I understood that MCAD is funded by the fines they collect. Is that true? I just raised this point to emphasize the participants how seriously to treat this. I mean, the MCAD is a state agency, so they have a line item in the Massachusetts state budget. I assume that's probably where most of their funding comes from. But yeah, I mean, obviously they also get additional funds from any fines and sanctions that are levied. So to that person who asked that point, that's probably one of the reasons why they do levy those fines. Next question. We have one elevator per building, 3 stories, garden style condo. We are modernizing the elevator so they will be unavailable for up to 12 weeks. An elderly owner is asking us to pay for a hotel, given that she is 99 and cannot go up the stairs. How should this be handled? Pam, I know we've talked about this before. Do you want me to answer it, or?
Yeah, I mean, we don't know exactly what would be required. I do know that on the government website for the MCAD, they bring up this particular instance as an example. And of course, they don't give you a clear answer. But in my opinion, if it's going to be out for 12 weeks and somebody lives on the 3rd floor and they literally have no ability to do the stairs, and they provide documentation for that, or it because, I don't know, they're in a wheelchair. Yeah, probably you're going to have to put them up in a hotel and grant them an accommodation. I think it's less expensive than litigating it at the MCAD. And my opinion, the MCAD would probably find some onus. I mean, the other suggestions are to offer help, which I don't know how reasonable that is. Offer to help them carry their groceries, things like that. If it's going to work for the person and they accept it as an accommodation, then you got off easy, but then you have to have somebody who's going to help them, and that person's going to have to be available.
Yeah, and I think Pam hit the best thing, is that oftentimes it's just less expensive to put the person in the hotel than litigate it. I mean, the boards needs to think of these sometimes as business decisions. And sure, you could have our office or another firm, fight this thing to the death for you, but you'd incur thousands of dollars in legal fees potentially, whereas maybe a hotel may not be that much. So, sometimes, you try to think of it as a business decision. Maybe there's a compromise. I think the question is it's a good question, and it's not one with a definitive answer that I can, point to a case or a statute or regulation to answer. Right. Will we be able to download the PowerPoint presentation? Yes, I think we either make it available on the website or we email it out. Either way, I'll make sure we follow up on that. I think a couple people asked that. Question on emotional support animals. Sore spot with many associations. Since the association cannot ask why emotional support animal is needed, owner just needs to supply a letter from a doctor. We have a unit with 2 people living there and have 2 emotional support animals. Does the association have to allow 2 dogs? Pam, you want to?
Yeah, I mean, if both people provide the medical documentation to support the need, then yes. I mean, I've even had one woman who said she needed 5 cats, and the medical professional said, yep, she's attached to the 5 cats. She needs them. She's going to benefit from them. And they had to allow the 5 cats. Yeah, the regulations do allow for multiple animals, and multiple residents within one unit can also request for an accommodation.
Yeah, I mean, and I think Pam mentioned this during her presentation. I look at it too sometimes on whether or not, when the person, let's say it's someone who's moving in and they make the request before they move in, and they already have the 2 dogs with them, right? Wherever they lived before, maybe dogs were allowed. In that situation, there's not going to be any therapist or doctor on the planet that says, oh yeah, Pam can get rid of her 2nd dog. I mean, of course not, right? Particularly if the person already has some emotional, trauma or whatever it might be, that would obviously only lead to more. But if the person is already living at the condominium, they have 1 dog, the board approved that dog already, and then a couple of months or maybe 2 years later, they ask for a 2nd dog. In that situation, I think the board can push back a little bit more and maybe go, when they're engaging in the interactive process, they can ask an additional question of the doctor or therapist, which is, why are 2 dogs as opposed to 1 necessary?
Yeah.
Next question. Are older constructed private condo buildings exempt from the Fair Housing Act? No, they are. Obviously, you hear about condominiums being grandfathered into certain building codes that you know, if your condominium was built in the 70s or 80s, it doesn't have to be up to today's codes, whether it's about for sprinklers or widths of doorways or whatever it might be. But no, the Fair Housing Act applies regardless of the year your condo was built. And if someone needs a modification or accommodation, the board will have to provide it. It sounds like it is incumbent upon management to put their understanding of the request in writing and ask for confirmation from the person making the request, correct? Yes, I would agree with that. If someone makes a verbal request, or even if it's a request in writing, but it's not entirely clear what they're looking for, I always definitely ask encourage the board or even our office to communicate back in writing, even if the initial communication was not in writing, to communicate back in writing to the person, say, just to confirm, is this what you want? Because you want to make sure that you're all on the same page on everything. So yes, definitely try to get that confirmation if you can. Can legal expenses related to the process be charged to the owner where the request originated from? Pam, you want to?
Yeah, absolutely not. And in fact, and I didn't touch upon this in the presentation, but if the person shows up, they move into the condominium and they have a dog and it's a no pet community and they already have the dog, and then somebody, you write the violation letter. We noticed you have a dog, no dogs are allowed. You have 10 days to get rid of the dog, or we're going to fine you. And then the dog doesn't disappear and the person just ignores the violation letter and you start fining them. And then eventually they say, oh, you know what? This isn't a pet. It's an assistance animal. And then they provide the documentation that supports that it's an assistance animal. You not only have to suck up the legal expenses for dealing with the back and forth if you would choose to hire an attorney to deal with it, but you also now have to wipe out the fines. It doesn't matter that in the initial stages, I even get the ones that say they came in and they admitted to me that it was a pet. Now all of a sudden it's an assistance animal. If they provide the documentation, unless you want to be the test case that says, well, they admitted they were a pet, but now they're an assistance animal, you basically have to allow the pet, the dog, and you have to wipe out the fines. The legal fees cannot be charged back.
Next question, I think we've already answered, but who pays for the accommodation, owner or trust? And can this be used as a special assessment if budgets can't absorb the cost? Yes. So as I mentioned, if it's in Massachusetts and the modification is to the common area, unless you meet one or two of the exceptions, the association does have to pay for it. And yes, if you don't have the money in your budget, then the association could do a special assessment for that. Next, thank you for your seminar. Can you discuss how insurance coverage can be considered if, for instance, an assistance animal is deemed high risk, for example, a pit bull type of dog, and may trigger non-coverage? Can associations or landlords require a certain level of liability insurance from the resident? Again, I think Pam already touched on both of these. The answer to the second question is no. You cannot require that the owner or the landlord or whomever it might be to have additional insurance. In addition, again, check with your insurance company. I would be surprised if they would actually deny coverage based on a certain breed being there. But if they do, as Pam said, well, maybe there's a burden upon the association to look for other coverage, but that could be a situation where you might be able to deny because it is somewhat of a burden that, obviously cancellation insurance, you can't have that happen. Next question, are condo associations subject to HIPAA privacy requirements? For example, are board members and property managers required to secure any medical documentation provided or not disclose certain things to building staff? For example, no dogs allowed, but a tenant needs an emotional support animal. Concierge would need to know that the dog is permitted, but are required to secure why they are allowed from everyone, including the staff. Yeah, again, you should disclose really nothing. Any medical information that's been provided to the board and the manager should really be for the board and manager's eyes only. I get the need to let the concierge know that, by the way, Mr. Smith will be bringing, now have a dog here. But again, just keep it very basic to what you tell Mr. Smith, that pursuant to the applicable laws, you had to grant a request for this person as a reasonable modification or reasonable accommodation. This is more of a statement. Letters are a joke. We've obtained letters from all. We obtained letters, and all the letters says it will benefit an emotional support animal. Associations' hands are tied. They have to allow the animal to avoid the discrimination claim. Again, unfortunately, that has become a little bit of the reality. I think we already answered this one a couple times. How do we address the master policy? No certain type of dogs to avoid increased premiums or possible cancellation, i.e. pit bulls. I just answered that. Is the association required to pay for modifications like stair lifts, ramps, etc., or can they approve it as an owner's expense? Again, we covered that. In Massachusetts, and I want to make sure I'm stating that clearly, in Massachusetts, yes, the association is required to pay for modifications to the common area. Do we have to pay for doggy station for an accommodated dog, or can we charge the owner for the expense if one becomes necessary? I don't know what a doggy station is. Pam, do you?
I'm guessing they mean like, like if they want to put something in so that there's bags so that they can pick up the waste. You don't have to provide that. The resident can have their own method of having the bags on them to pick up waste. So you don't have to accommodate the dogs, just the residents.
Yeah. Next, what if a neighbor is allergic to the animal? Again, this goes to the competing disability situation that Pam talked about. And, first of all, the person with the allergies, I would make them provide a letter that stating, are they allergic? And also, I also ask the question sometimes, well, how allergic are you, right? I mean, there's dogs everywhere in society. If you're walking down the street, there's a chance, you just go for a walk in your neighborhood that you're going to pass a dog. You're probably not going to have a severe allergic attack that might kill you or send you to the hospital. Certainly, though, if you went to somebody's home who had a dog for dinner, that might be a situation where you may not be able to tolerate that. So, to what extent is the person allergic? And is there a way for the dog and the person with the allergies to coexist? And that's the question. If at the end of the day, the answer is no, there is some case law, not for Massachusetts, so not binding precedent, that perhaps the person, whoever was there first, their rights might, have some precedent there. Are we allowed to call or reach out to the medical professional to confirm the documentation letter is true? Only if, I think, Pam, the answer here, correct me if I'm wrong, is only if the resident has given you permission to contact their doctor, correct?
Yeah, I would typically request the permission. I often find that the letters will say, if you have any questions, feel free to call me, and it'll say the phone number at the bottom, and that'll be from the medical professional. But I would probably say to the resident, we want to just call just to verify that this was absolutely written by a medical, from your medical provider.
Right. Does this apply to short-term rentals? I'm guessing the question is about dogs. So I think that I'm guessing they're asking about that. If you're asking about something else, I don't know. But yeah, it applies to not just full-time residents, but short-time rentals. If someone is doing a short-term rental, and someone wants to bring their dog with them, yeah, they would have to, meet all the same criteria we've talked about.
It's another good example I never even thought of.
Yeah. Can you ask to provide specific genetic testing for an animal? Again, I'm assuming this is to determine if it's a mixed breed, do they have some pit bull or someone else in there? Given the fact that you can't deny a dog based upon speculation or generalizations, I would say no, you can't ask for genetic testing of the dog. Next is it's like a kind of a two-parter here. Received the following email from an owner's daughter. Unfortunately, my mother was diagnosed with ALS last year, and her condition continues to get progressively worse. She is now wheelchair bound, and as we prepare for the spring and summer season at the lake, we are challenged with how we are going to get her in and out of the building. Could you please let me know what the complex can do to make access to and from the building handicap accessible? Similarly, it'd be helpful to know what can be done to get her up and down the flight of stairs to our unit that is on the second floor. Please advise on our options. So that's kind of interesting because it's a very general request saying, almost asking the board to say, well, what will you do? I guess I would kind of turn it back around to the owner and say, well, you know best what you need to accommodate your disability. So if you're in a wheelchair, okay, well, then you probably need a ramp. But I think that, again, that's all part of the interactive process, but the disabled person is really the only person who knows what they need for their disability. So I think you need to go back and ask them that, and have that interactive dialogue with them to figure out what they need and whether or not it can be accommodated. Can you provide the guidelines that says it doesn't matter if insurance companies will not insure a type of dog you'll have to accommodate it. Pam, you mentioned this. I wasn't familiar with that. I think, did you say there's a case on that or something? Or-
No, there's a memorandum that was distributed, I believe in 2013 by HUD and the Department of Justice. They typically shoot out these
Oh,
things periodically, and that specific memorandum. So if you want to contact the office, I could certainly email you a copy of that.
All right. These letters as a disabled person take time and money to get from healthcare providers. Often we remember as board members. Yes, they do. And certainly you always need to keep that in mind. Do we have to allow someone who already has an emotional support dog to get a second emotional support dog? This is in addition to his first dog, not a replacement. Again, I think we answered that question earlier, so I don't need to answer it again. I see this is being recorded. We'll be able to access this video at some point for the future to refer back to it. Yes, I do think we post these on the website. It may not be today. It usually may take a couple days, but yes, we do post these on the website. We have a growing number of approved emotional support animals in our 131 unit condo, pet-free in the docks. One dog on a 15-foot leash in the lobby ran to a resident and jumped on her. Owner was notified verbally and in writing. Our ESA rules were approved by MEEB. Can require animals be in carriers or owners' hands in common areas and issue fines, violations. More owners are complaining about the ESA. I usually say no, you can't require that the owner carry the dog because of two reasons. One, what if it's a 150-pound dog or a 100-pound dog? Or even if it's just a smaller dog, but maybe the person, isn't that strong and maybe they're frail, and just even if the dog weighs 20 pounds, they can't carry it. But what you can require is that the dog be on a shorter leash. You could say a leash of no more than, maybe 3 feet or 4 feet. I don't know what the shortest leash you could have. And then obviously you all see those retractable leashes. You could require that it be on a non-retractable leash of not more than 3 or 4 feet, particularly when it's inside of the building. Once it gets outside, then maybe it can be on a retractable leash. And as far as about issuing fines, if, again, if you put some rules in place specific to emotional support animals, we get that question a lot, was what if they violate it? I'd say you treat it like any other violation, right? Maybe you send a warning letter. If that doesn't work, then maybe you fine them. If that still doesn't work, maybe our office gets involved and informs the owner that, hey, listen, you're going to keep being fined. And eventually, if they're really not complying with these rules, even though it is an emotional support animal, you could demand that the dog be removed. Now, they're not going to do it. The only way that's ever going to happen is if you take them to court and get a court order forcing them, to have the dog removed. Next question is, why do we have to offer the options? I'm guessing that question was asked at a moment in time when we were talking about something, so I don't know what that question is referring to. I apologize, Kim, if you're still listening. Hello, if a resident has an approved emotional support animal and notifies us that they're looking to get a second one, can it be denied? We answered that question. Can we get a copy of the slides? Yes, we will. Hi, we have elderly residents in our association that apparently do not have internet or access to email. Although we provide our condo meeting minutes and financials on our online portal, are we obligated to provide hard copies to residents who are not able to access the online portal? Can we charge a fee for providing hard copies? What do you think on that one, Pam?
I mean, absolutely, it can come up as a request for accommodation. I don't know, just the fact that they're elderly would suffice, but I would suggest that it would probably just be easier, and I wouldn't charge a fee for the hard copy.
No, I mean, the condom, so I think this is not necessarily even a disability question. I mean, again, you just have an elderly resident, they're not disabled, but they don't use the internet. And the condominium statute does say that owners are entitled to, request and receive records. And so, and also usually condominium documents, and even the statute talks about that. I think on an annual basis, you have to distribute like a financial report. So yeah, unfortunately, if an owner doesn't, use technology, you would have to possibly mail it to them or make it available for them to pick up. Can we deny online certificates that the ADA say are not? We already answered that. Rules state that the animal must be in owner's control at all times on a leash in the common area. Yeah, so again, I think that goes back to the question about the length of the leash. So yeah, that would be a reasonable rule to have, that they must be under the owner's control. But again, you can't force them to carry it. Does it matter if a physical common area accommodation request is from a tenant or an owner? No, it doesn't matter whether the person is a tenant or an owner. And in fact, people aren't going to like to hear this, the law even applies to guests. So if I live at the condominium, but my friend or brother who visits me periodically happens to have a service animal or an emotional support animal, the board would actually have to allow him or her to bring it when they come to visit me. Again, you make that person go through all the same hoops and hurdles that you would anybody else, but it would be for guests as well. Does an association have to allow a service dog to be off leash on common areas? Does the association have no say regarding service dogs? Pam, do you want to take that first?
So in general, you don't have to allow the service dog to be off leash. However, there may be an exception. If that person can provide medical documentation that supports some reason or need for their particular service dog to be off leash, then you may have to allow that. I did have that request come one time, and the gentleman claimed, and his doctor supported it, that he had PTSD. And there was something about the dog walking, in front of him and alerting him. And in order to do this, it was required that he be off leash. And I, based on the medical documentation, that was the only one time that it was an exception to the general rule that you can impose like leash requirements and the resident has to have control over their dog.
Yeah. Next, can you restrict animals from a pool area where there are many children? Can you specify that animals must be on a leash or in a stroller in this area? Can the impaired person go out and leave the dog home? Three questions there. Pam, you want to?
Sure. So you have to allow the disabled person to bring their animal to the pool area. However, you do not have to allow the animal to be in the pool. That would be, we say, a Board of Health issue. It wouldn't be sanitary. Can you request that they specify that it be on a leash or a stroller? I mean, definitely on a leash. I suppose maybe you could say carrier or stroller, but if they're on a leash, at least, yeah, you can require it, just like it's any other part of the common area. You can require that they be in the control of the resident. Can the impaired person go out and leave the dog home? Yes, they can. And a lot of people get really hung up on this because you're saying this is an emotional support animal and that the person needs it, right, for support, but then they can go to work without the animal. Doesn't matter. Basically the medical provider is saying that this animal still offers them some sort of support when the person is home with the animal. So the fact that they leave the animal home and go to work does not disqualify them from having the assistance animal.
All right. This is back on that short-term rental. To elaborate on my question about short-term rentals, if the complex allows short-term rentals and I am renting my unit and a potential renter asks for an accommodation, can I deny them from renting? I don't think so. It's a little bit more of a landlord-tenant question than a condominium one, but I'd be very surprised if there's any exception for a short-term rental. I'm not aware of one in the law. Our facility will need to refurbish the sole elevator or require the elevator to be shut down for 6 to 8 weeks. Is the HOA responsible for paying the housing cost for a resident? We answered that already. If a resident is physically disabled in a wheelchair and their association has a pool that does not have a handicap access or handicap chair, would a handicap chair be a reasonable request, and can they require the resident to pay? Yes, it would be a request. So someone would come forward and say, listen, I need this lift or something to get in and out of the pool. That would be a reasonable request. And again, because it's a modification to the common area, if we're talking about a Massachusetts association, the association would have to pay for that. In a townhouse style complex, does the association still need to pay for ramp leading to a single unit? So that's a good question. So again, this is not like a garden style where, there's one set of stairs for the whole building. Everyone's got their own front entrance. In that situation, you actually need to look at the documents and see how they describe the steps. If they happen to describe the steps as being part of the unit, which is unlikely, then the owner would have to pay for it. But if the steps are common area, even though they're for the exclusive use of the unit owner, they are still common area, and therefore, unfortunately, the association would have to pay for the ramp in that situation. This is a question on parking. What if you have 1,400 spaces? Oh, that's a lot of parking spaces, and allow 2 cars per unit and have over 800 units? Well, my math, I'm not too good at math, but that math doesn't work out because that would be 1,600 spaces. So I'm not sure where all of them go. I would need to know more, frankly, about how the parking's set up there, whether or not it's deeded or assigned. So you feel free to contact me offline, and I can happy to discuss that with you if you're still on. Parking. 10 years ago, council advised that a resident who had a parking space wanted a handicap space closer to entry. No problem. However, we wanted the owner to allow the trust to use her deeded space, and we were told we could not do that. So she got 2 spaces. Do you agree? No, I don't agree. That I don't think the person should get the windfall of getting 2 spaces. If you have 1 space and it's far away and you need a space closer, there should be a swap where the owner's space becomes kind of a guest or visitor space. If you are doing a swap of parking spaces, how formal does that need to be? Is it just an understanding or agreement or a deed issue? Well, typically it's only temporary in nature because it's only going to be for while that disabled resident is there. Now it could be for 5, 10, 15 years before they move out. But I would typically do it, not just an understanding. I would have it in writing, but I don't think it needs to necessarily be recorded at the registry of deeds, unless for some reason you are making it permanent, but typically they're only temporary. How do you validate any handicap placard which people can easily reproduce? I would assume you can validate by checking with the registry of motor vehicles. You can ask them to provide it. There's usually like an expiration or a number on there. And I think you can probably validate that with the registry of motor vehicles. This is back in that question about the 800 parking spaces. Again, I need to know more about how the parking is assigned there. For either as emotional support animals or assistance animal, can the condo association request the owner to provide a pet license or whatever required by the state in the municipality? Oh, I think that means, yeah, like you have to license your dog. Pam, you want to?
Yeah, absolutely. You can, that would be considered a reasonable rule, that you require that the assistance animal have a license from the city or town where you reside. And you can also request that they at least have the rabies shot from the vet. So you can request proof of that, because that's typically a requirement of any town or city that dogs be vaccinated with at least the rabies shot.
All right. Okay, I'm going to give you the next one as well. Having a service and emotional support animal only applies to housing, correct? So online currently, a certificate for a fee is being promoted to allow you to bring your pet anywhere. Is there any such certification which does not apply to housing? Do you want to?
So I think what you're probably talking about are those certificates that I mentioned with the picture of the animal, and it says this, Muffy is a registered service animal. In housing, that would not substantiate the documentation required under the law. So you could request the medical documentation. But, and I'm not an expert on ADA per se, but like if somebody's going into a restaurant with a dog or a shopping mall or whatever, typically the certificates and the service vests are going to be enough, but that's not going to be enough in the housing complex.
All right. What to do when a real estate agent tells a buyer that they can have as many animals as they want, and the buyer moves in with 2 dogs and our master deed says 1 dog per unit. So again, you would treat it like any violation, right? So you would send that buyer immediately, or now an owner saying, hey, welcome to the neighborhood, but by the way, you're in violation of the documents because you have 2 dogs and we only allow 1 per unit. And then inevitably, you're probably going to get a response that says, oh, well, my dogs are emotional support animals. And then you go through the whole process that we talked about and say, okay, if that's the case, then please, provide us with the documentation from your medical provider, et cetera. Can you require a pet deposit for a non-service comfort animal? I thought this was illegal. So if you're just talking about, just a regular, your association actually allows dogs, and so I move in and I bring my dog. Yeah, but it has to be stated in your documents that you can require some type of pet fee, but you cannot charge a pet fee for assistance animals, but for regular animals you can, provided it's stated in your documents. Next question. Hi, Pam, you should mention vests. Remember, I thought the dog had to have it. Can you can use me as an example. You want
Yeah.
to take that?
Sure. Hi, Donna, if you're still there. Yeah, so basically the question that was specific to a particular case was property manager thought that because it was a service animal, we could enact a rule that required the assistance animal or service animal to wear a vest identifying the animal as such. The regulations basically say, no, you cannot require the vest. So the fact that, you know, typically out and about in the regular world, you see service animals wearing vests, an association cannot require it. If they want to voluntarily wear it, that's fine.
Right. If it is in the rules and regulations that all residents who have animals pay a fee up front for the animal, then we cannot do that if it's an assistance animal. Correct. You cannot charge a fee for an assistance animal, even if you charge that for all other animals. Next question. So we cannot restrict someone's dog from relieving itself on our front entry pavers or planters or lawn. Pam?
I mean, it depends. So if a certain area of the lawn is an exclusive use to certain unit owners, then you could say you can't use those areas. I think it's reasonable to say, you know, you should avoid areas that are landscaped with bushes and flowers, but in general, anywhere that the resident or visitor is allowed to go on the common area. So if it's typical, you know, if they happen to be walking down the walkway and the dog relieves themselves, well, then that resident's required to, you know, clean up the waste. But you can't specifically say you can't walk the dog on the walkway or, you know, allow the dog to relieve itself there because it might have an accident. Same thing goes with the lawns. If residents are allowed to walk on the lawn areas, then that assistant animal is allowed to walk on the lawn area with the resident and therefore relieve itself.
Next is there's a dog in the complex as a comfort dog. The dog was constantly barking and another resident complained. The neighbor has now noted that they have muzzled the poor dog and leaves the dog alone for many hours crying and upsetting many neighbors. What can be done? So assuming you have, you know, typical rules or restrictions about no nuisances, or maybe even specific ones about, you know, dogs cannot create a nuisance. Again, you would treat it like any other violation. You'd send that dog owner a warning, fines, and then maybe escalate it from there. You know, you got to be a little bit more careful in these assistance animal issues and make sure that, you know, it's a legitimate, you know, issue here, and that it's not just someone who's overly sensitive to noise or whatever it might be, but, you know, you would treat it like any other violation. Can we tell people they cannot walk their emotional support dogs on the grass or any other landscape areas? There are areas on the property that are not professionally landscaped where dogs are allowed to go. Pam, I think, just answered that one. Can we request updated doctor's note yearly? In my opinion, you can't. And really, if you think about this logically, you know, so somebody moves in with their dog, or maybe they're there and then they subsequently ask for the dog and they give you the doctor's note, you know, and the doctor says that, you know, Pam has this disability. A year later, I mean, the odds of a doctor ever saying, oh yeah, Pam is cured and, you know, no longer has stress or depression or whatever it might be and no longer needs a dog, it's not going to happen. So, you know, maybe legally you can, but just, you know, a little common sense. It's just no doctor is ever going to say that, okay, yeah, they don't need their dog anymore. And then what, Pam's going to drop her dog off at the pound after a year or 2 years? It's not going to happen.
And then I'm going to be depressed again and I'm going to qualify for a dog.
Exactly. Would MEEB plan to take any initiative to petition clarification on specific types of stock letters? We have received 8 copies of the same letter from the same therapist across 4 different associations for emotional support animals. All that is different. All that's different is the resident name. Yeah, I mean, Pam, I mentioned that, you know, I probably know those people. If you've gotten 8, I've probably gotten 20. So, you know, from all of our various clients. I mean, you know, about some type of initiative to petition. There is some legislation that's been filed in the past in Massachusetts to kind of make it a civil infraction to misrepresent that you need an emotional support animal. It's never made it that far. I do track it as the chair of the legislative committee for CAI, but so there might be some avenue there to stop this. We'll see if it ever gets traction. Please review the guidelines and law about a handicap ramp and the number of steps in the area that are involved. I did talk about this, but it was a while ago now. So if you're still listening, if it is 5 or fewer steps, then the association has to pay for the ramp. If it is more than 5 steps, then the association does not have to pay. We don't allow dogs here. What we do in the case when a new resident brings a dog, then we tell them they are not allowed, and a week later they come with an internet letter. Can they be fined $500 for the time that they did not have the letter and the fact that they didn't ask or request accommodations before bringing the animal? Pam, I think you already answered this, Pam.
Yeah,
But if you wanna...
I answered it. You can't, once they comply and they qualify, you have to waive the fines. It sounds weird, but it's the way it is.
Right. What if an owner or a trustee owner requests the handicap request and is not handicapped themselves?
Yes. They can request for other people.
What if a blind person does
Oh,
not pick up after the dog? What can a condo association do to keep property clean in a sanitary condition? What do you think about that one, Pam?
what if a blind person does not and cannot pick up? Oh,
Yeah, basically they say the dog, defecates in the common area, and they're sort of saying, well, I'm blind, I can't see to pick it up. I think that's the question.
I think that's another accommodation, maybe.
Yeah,
right?
I don't, but I think the association could push back a little bit there and say,
Yeah.
well, not sanitary just to leave
No.
dog feces outside. So I think the association could push back a little bit on that one. Garden building with unit doors directly facing one another across from the hall. Board does not permit video doorbells because residents in hallways can be recorded without knowing it. Disabled resident wants a video doorbell because it's hard for them to get to the door quickly. What about the trade-off between privacy and rights for the disabled? It's an interesting one, Pam. If you have any thoughts on that one, but
So they don't permit it because they could be recorded. I mean, when you're recording a hallway, that's a common area and there's really no expectation of privacy in a common area. So I'm not so sure that it's really a competing trade-off in that instance. If a resident needs it as an accommodation because they're disabled and the only drawback is that it's going to record some of the hallway and you might walk by and get captured in the recording, you have no reasonable expectation of privacy in the common hallway.
Yep. All right. When asking the court in declaratory judgment action, who is the other party? Would naming the parties claiming the accommodation be a potential violation? So I think this is the question on the competing disability. So you have the person with the allergy or the fear and the person with the dog. And I've talked to clients about this and sort of said, well, how are we to decide whose disability wins? Let's throw it into the court. And so the other parties would be those two people. You would name, the association would basically be the plaintiff, I guess. And then you'd have essentially two defendants, party A with the allergy or the fear, and party B, the person with the dog, and say, here, court, here are all the facts. You tell us what to do. What is the fine? What if the fine is for other violations, i.e. ESA dog is unleashed when outside of unit, leaving dog feces? Can we leave that fine to the owner? Yes. If they violate the rules, you can issue fines in that situation. I suggest warnings first, though. For either ESAs or assistance animals, can the condo association request the owner to provide a pet license or certification, or whatever is required by the state? Pam answered that. Yes, you can request that the dog owner provide vaccination records and the dog's license from the city or town. Piggybacking on this, the VA allows for assistance in cost to install a wheelchair ramp. Can the association request that the owner look into this option if they disclose they are a veteran? Yeah, I think that could be part of the interactive process. Again, normally the association has to pay for it, but if the owner is able to get some type of grant or something from whether it's the VA or some other association, I think it's fine for the board to have that conversation. The board can't force the person, but the board can certainly have that conversation. Do you provide your clients with a specific form to address the support animal verification? We have a form that we've developed based upon court cases and regulations, and we tweak the form as more court cases and more regulations come out. I am always hesitant to provide it to a client because of the fact that we do tweak it, and that if I provide it to you today,
Mhm.
and you use it today, but then maybe 3 years from now you use it again and you don't check with me, maybe there's some court case that turns out that question number 5 on that form we can't really ask. So I always tell clients hey, I'll give this to you, but please, before you don't just blindly use it. And not just that, each case is different, right? Maybe someone's asking for 2 dogs, so maybe you want to add a question to the form. Or again, maybe when they come with the request, they provide you with a letter on their doctor's letterhead that has everything that would be in the form. In that case, you can't use the form because they've given you a letter. So just be careful about just blindly using the form without checking with the attorney first. Can you clarify on your question about not charging for printed documents? Doesn't Mass General Law allow for owners to request copies, but they pay for it? Yeah, so this was on the request for records. The statute does say that an owner is entitled to request, copies of certain association records. In the association can charge the cost to copy them. So it's really, it's a pretty nominal fee. But again, I think if this is different though, where if you're providing everything online and the owner doesn't have online access, I think there you might actually have to provide it to them at no charge, because you have to provide them with the same thing that you provide everybody else.
Right.
In conclusion, it appears that in Mass, a board of trustees of a no pet condo has no rights at all regarding comfort animals, even if fraud is suspected. The law is not on our side. It's not really a question. I'll leave my own personal opinions aside. Next is, how do you define excessive barking from dogs? Well, it's not something you can define. It's not black and white. It is subjective. And I always give the examples that, listen, dogs bark, right? When the owner comes home from work and the dog's happy to see them, or the mailman shows up and rings the bell and the dog gets excited, the dog's going to bark, but that's not excessive barking. But if it's at 2 a.m. and the dog is barking for a while at who knows what, that's excessive. Or maybe it's even during the day and the owner goes off to work, but the dog barks for 7 hours continuously during the day, that's probably excessive. So there's not really a black and white definition to that. Can you enforce a rule that an animal must be in a stroller in the common areas? No, I don't think you could probably enforce that. I have a seeing-eye dog and I am trained to pick up waste. All right, that touched on a question from earlier. Thank you for providing that information. About audio recording with video doorbells. I thought the law in Mass was that persons being recorded needed to have actual knowledge they're being recorded, not just that they could be. Correct. So Massachusetts is a dual consent state. So usually those doorbells should not be recording audio because they could pick up conversations that people have not consented to being recorded. Thank you so much for the information. And then finally, last question for here. Back to copies. If we have a posted sign about how much copies cost, $1 per page, is it okay to leave this up? And if someone says they need an accommodation, to waive the fee? Yeah, I don't know. Yeah, I guess so. Again, I need to know a little bit more, but yeah, I mean, the board could obviously waive the fee if they wanted to. Whew. Done. All right. Thank you, everyone. Wow, still some people here. We really appreciate you attending. We hope you found this informational. We will make the slides available either on the website or email them out. I can't remember what we do. And we will also be posting the video of this online.
Thanks, everyone. Have a great day.
Thank you. Bye-bye.